So I have a very interesting topic to talk with you about today, and that's the 5 parts that are in every dispute. So any estate, any probate case, any trust case that winds up in litigation is going to go through this 5-part process. They all follow the same process. So we're going to learn about that today. My name is Erik Broel. I'm the founder and CEO of Georgia Probate Law Group. We're a law firm and we focus exclusively on helping families that have experienced the loss of a loved one. So we work a lot with estate and trust litigation cases. We also help in situations where it's more peaceful, and the main goal is to settle the estate properly and make sure that everything is done right. So let's jump into our topic today. So as I mentioned, there are 5 phases or 5 parts of every dispute. The first part, and the first thing that's going to happen, is pleadings. Now, what are pleadings? Pleadings are just when you make a formal allegation or accusation against the other party. So I'll give you some examples. In an estate situation, a pleading or an allegation may be, I think that the will you've presented to the court is fraudulent or invalid, and I think that the court should overturn that will. Another example could be, I'm not sure what's going on in this estate. I've asked for information. I'm not getting any information that I asked for, or the information I'm getting is not making sense. And so I would like a full accounting of this estate so that I can determine whether it looks like things are going correctly or not. Another example would be, I know that the things that are going on in this case are not good, that the executor is not following all of the duties that an executor has. And so I would like for that executor to be removed, and I would like a different person to be put in that position that will handle the estate properly. Each of these are examples of allegations. There's many, many more. That's not an exhaustive list. However, those are some potential and often pleadings that we often see in estate cases here in Georgia and in our office. So once the pleadings have finished, then we go to the discovery phase. Now, discovery is just a fancy word for investigation, and it allows us to investigate the facts surrounding the allegations that were made. And so there's a number of tools that we can use to do that. And so one example is we can send off written questions to the other side and require them to answer those questions. We can send off document requests to the other side. We can send off document requests to third parties and get these documents back that may have evidence in them that will help support our case. We can also bring folks in to a deposition where we have a party we're going to depose, and we're able to have a court reporter there and ask them questions and make them answer those questions on the record so that that can be used as evidence as well. Finally, we can go inspect property or inspect a home or something of that nature if it's applicable in that particular case. Now, why are we doing all of this? Why are we doing this discovery phase? Well, because we have to produce evidence to support the allegations that we made in the pleadings phase. If we don't have evidence to support those allegations, then when we go in front of the court to present our case, it's not going to go well. The court's going to decide against us because the court can't just look at allegations of what we think's going on. The court has to look at the evidence we can produce showing what's actually going on. And so that's why discovery is important. The next phase is, or the next part is motions. And I'm going to draw a little asterisk here because I've put motions right here on my diagram, but motions can occur during the discovery phase. They can also occur leading up to trial. So it made the most sense to put them here, but just understand motions can move around a little bit and they happen at different phases. So what is a motion? A motion is any time we ask the court to do something. We ask the court to act during a case. And so some examples of that. We could say, Judge, I've sent off some requests for information or documents to the other side. They are not responding to me and they're not giving us the documents we've asked for. Please make them give us the documents. That would be an example of a motion to compel. Another example is, Judge, we have done lots of discovery. We've produced a lot of evidence. In fact, the evidence that we've been able to gather is so abundantly crystal clear that it shows that there's no need to have a jury, there's no need to have a trial in this case. The court can just decide right now as a matter of law and in this case, and they can decide in my favor because the evidence we have is so clear. That would be a motion for summary judgment. And so those are two motions that are often made in cases. To give you some examples, there's many other types of motions that could be made. Well, then the next thing that would occur is we would move on to the trial or the hearing of the matter. Now, quick note on this. Throughout the case, there can be and probably will be other hearings. So I gave you an example of a couple of different types of motions. If we filed a motion for summary judgment or we filed a motion to compel, the court will often order a hearing on those motions where we'll go to court and we'll be arguing about those particular items in the case. When I say trial here or major hearing here, what I'm talking about is the trial of the case. So at this trial, the court is going to hear and look at the pleadings we made at the beginning. We're going to present the evidence that we were able to discover in our investigation. And we're going to be asking the court to decide in our favor on the basis of that evidence. Now, the other side is going to be doing the same thing, trying to get the court to decide in their favor based on the evidence that they're presenting. But at the end of this hearing, at the end of this trial, that's going to decide all the matters in the case. And so the case will be finished once that ends. Now you'll notice I have a fifth part up here, and that's appeal. Now appeal is optional. Appeals are not used all the time. In fact, I wouldn't even say they're used frequently. However, I want to talk about them because when we talk about an appeal, it's not what most folks think. An appeal in our sense is when you believe that the trial court made a mistake. They made a mistake of law on a ruling. And we want to go and ask the higher court, the Court of Appeals or the Supreme Court, please fix the mistake that was made. Change that ruling to fix it so that it's a correct ruling under the law. You don't just get to file an appeal because you don't like the result. And that's what TV portrays, but that's not an accurate portrayal. There has to be some legal mistake we can allege that was made by the court. So that's our process. That's our five parts of a dispute, start to finish, that every litigation case goes through. Now, I've got one other thing I want to talk to you about briefly, and that's settlement. As a case is going on, there's often going to be settlement talks between the parties. In fact, in Georgia and virtually every metro county, the judge at some point is going to order a mediation. And a mediation is nothing more than a formal settlement discussion where both parties and their attorneys come together in a conference room and they talk about their issues in an effort to try to settle them. And there's a mediator there as well. Now, mediation is not binding unless the parties come to some sort of agreement and agree to make it binding. But when we look at once litigation starts, there's two paths that it can go down. It can proceed all the way to a path of the final trial of the matter, and that would be the conclusion or the end of the case. Or it could end at any point before trial if the parties come to some sort of negotiated settlement or some kind of an agreement. That agreement could be anything under the sun. It could be one party dismisses entirely. They decide to quit fighting over it. It could also be where the parties come to an agreement that's some sort of a compromise between what the various allegations have been. The sky's the limit. We've seen all sorts of different types of settlements. That's our 5 parts of a dispute. Those are the ways that a case can end once a dispute has begun. So I appreciate your attention. Thank you very much for watching. Please feel free to reach out to our office if you have any questions. Thank you.